on YouTube. All right. Let's go on the record on cause number DC 181418, Jeremy Haltom versus Don Triplett. Council, make your appearances.
Reagan Herod here on behalf of Don Triplett.
Brandon Tittle on behalf of the plaintiff, Jeremy Haltom.
Okay. And I understand that Mr. Gibson was on the line earlier, but he's not on it now because he has another hearing, but he doesn't need to be here for the hearing. Is that correct?
Yes, Your Honor.
Okay, let's go ahead and go forward.
Your Honor, this is defendant Don Triplett's motion to reopen for a limited purpose, motion to expunge lis pendens and for sanctions. I would note that opposing counsel filed a motion for continuance last week, did not get a notice of hearing on that. I'm assuming in part because of the devastating weather. And I'm assuming he's going to bring that up, but I just want to let you know ahead of time that they have asked for continuance.
Let's deal with that issue first.
Your Honor, we filed an emergency motion with the bankruptcy court for a determination of who has jurisdiction over this issue. This is an issue of the debtor's homestead property, and it's my belief under 28 USC 1334E and 28 USC 157 that the district court has exclusive jurisdiction over the debtor's property while it's in the bankruptcy case. And obviously, because the standing order of reference, the bankruptcy court should be the one hearing this. So we filed an emergency motion with the bankruptcy court. The hearing was scheduled to take place last week, but because of the storm, no hearings were held. That hearing has now been pushed to this Friday morning. And so I think it makes sense to wait to rule on this until the bankruptcy court has had a chance to determine what their jurisdiction is over this issue. We had a prior hearing on the lis pendens with Judge Rhodes, and it was her opinion that she did have jurisdiction over this issue. She advised the debtor to commence an adversary proceedings under 7001 of the Federal Rules of Bankruptcy Procedure. That was not followed by the defendant in this case. And so we would like to clarify her ruling. Her ruling was that she had jurisdiction. I would like to clarify whether she has exclusive jurisdiction. If she has exclusive jurisdiction, this state court would not be able to rule on any matters regarding the debtor's homestead property. And so we would ask that this court continue the hearing on these issues until after Judge Rhodes in the Eastern District of Texas rules on whether there's exclusive jurisdiction or not.
So I've read all of this. Can you guys hear me okay? That sounds like there's some feedback. I tend to disagree with you. I think I probably do have jurisdiction, but I would rather, I tend to agree with you that I'd like a continuance just to make sure that I'm right about that, because I don't want to make an order that gets vacated by the bankruptcy court. And so how quickly does the bankruptcy court generally rule on this, and how quickly could we get an order from them?
So she'll usually rule from the bench, and so we would have a ruling and an order probably entered sometime quickly, either the end of the week or early next week. If our motion is denied, we would like to have a few days to respond to the merits of the motion, because we haven't done so yet. Our objection is purely on jurisdictional grounds. And so we would like to have a hearing probably sometime the end of next week, once we've had the order in place from Judge Rhodes and we've had a chance to brief the actual merits of the underlying issues.
Response?
Your Honor, it's a little bit funny. I mean, this has been an exercise in delay from our perspective. You heard Mr. Tittle say that it was his belief that under Section 1334 that the bankruptcy court has exclusive jurisdiction. We were before that court on a motion to avoid a lien under Section 522F, and they said, bankruptcy court, you have no jurisdiction whatsoever because we didn't object to this homestead exemption and it's outside of the estate. So the proper venue is the state court. So they didn't brief the merits then. And then when we filed in this court, they didn't brief the merits again here. They went ahead and went on jurisdictional measures, which if you had declined that argument, you would have taken up the merits. They should have briefed the merits at this time. And I think that they didn't do so because they don't have the ability to actually to do so. We did talk about juggling this hearing for purposes of the bankruptcy court. We had to set this out multiple weeks when we called in initially. So we were reluctant to just say, yes, we'll continue it without having a date coming up. My client has had this lis pendens affecting his property for 2 years. He can't take advantage of historically low interest rates. He can't tap into the equity of his house. It's gone on long enough. And so I can't just agree to keep punting it out. We wanted to get it heard by you. If you want to wait for the bankruptcy court, we understand. We would like something relatively quickly because we do think she will rule from the bench. We think we will know Friday whether or not she has exclusive jurisdiction or just that she has jurisdiction, which I believe she's going to say that she has it and you do too. The issue with the bankruptcy court is she's not well equipped to do a summary proceeding under section 12.007. The Supreme Court, the Texas legislature in their wisdom gave a summary proceeding for this type of issue. A lis pendens should not be able to be there for 2 years. It should be dispensed with quickly. And to file an adversary proceeding subject to discovery is not the venue or procedure that the Texas legislature designed specifically to protect the homestead. So we would like, if you're going to wait for the bankruptcy court, to get this done relatively quickly.
How does March 8th at 11 o'clock sound? Does that work for you guys?
It works for my schedule. I'm available then, Your Honor. We would like it before then, but if that's your first available.
Your Honor, that works for me too.
That's just a couple weeks from now, March 8th.
Yes.
Okay.
And Your Honor, can I make one rebuttal statement on the record? It'll be very brief.
Okay.
It was our argument that 522F was not the basis by which they could strip the lien, the lis pendens, because it was not a lien. That issue was granted, so they weren't able to go forward on 522F. We never got into the issue of whether they had exclusive jurisdiction or not.
Okay. All right, we reset this to March 8th at 11 p.m. If you could go ahead and, Mr. Tittle, you filed the motion for continuance, so why don't you go ahead and set up the notice for that, and I'll let the clerks know that it's set for that time, okay?
March 8th at 11 a.m., you said?
11 a.m., yeah.
Perfect, thank you.
Thank you, Your Honor.
All right, have a good day, guys.
Thank you.
Okay, I see a couple other lawyers here. Mr. Miller, Mr. Stewart, I assume you're here on the Zubara case, is that right?
No, Your Honor, I'm here on the Dallas Berkshire Partners case, scheduling conference that's set at 10.
Okay. Do you have an agreed order?
Yes, I represent the defendants and an agreed order was submitted.
What was the name of the case again?
Dallas Berkshire Partners versus Robert Quick.
When did you submit the order?
It was submitted before last week or late last week. Plaintiff's counsel submitted that.
Okay, let me take a look.
The date, sorry. It was submitted on the 11th of February.
Let me just look at it. Oh, it looks like it's been taken off the docket, so that probably means I've signed it, but let me double check that. Oh, no, it hasn't, sorry. Probably have not signed it. Okay, let me take a look at that.
We also had a proposed, an agreed protective order that was submitted to that is waiting.
Did I sign that one?
Okay.
Have I signed that one yet?
No, sir. At least it's not showing up on the docket as signed.
Yeah, it's been kind of a crazy time.
Yep, I understand.
Let me see. I want to get that taken care of for you, so let me look at it. let's see. I see both of those. Let me see. We'll try to sign those, print those out now. All right, Peyton, I'm printing out 2 orders right now. Can you grab those from Rhonda?
And Your Honor, on that scheduling order, and plaintiff's lawyer is supposed to be on too at 10, but we had provided two options for dates. We were in agreed to both, but the scheduling order has 2 trial dates on it. They're just a week
Okay,
apart.
that's probably something we want to talk about. Okay. Apparently my computer is frozen now. Let's see what's going on here. All right, I apologize. I'm going to be right back. I need to get this printed out. It's not working on my computer, so I will be right back. Reagan, just let people know that I'll be right back.
Hey, Robert, this is Kelly. I just texted you.
You did?
Yeah.
What'd you text me?
Robert Byrne. Wrong Robert, Mr. Miller.
Oh, okay. I'm confused, which is nothing new.
You're on mute, Robert Byrne.
Yeah, I've got your text. Thank you. You can hear me now, right, Kelly?
Yes.
Okay.
Chuck, are you on there? If you can hear me? He's trying to come in by phone.
Can you hear me now?
I can, yes.
Okay, I was muted.
Okay. Just want to make sure you're there.
Yep, you can see my name on one of the squares, but no camera, obviously.
Yeah, no, that's the way it works. The judge went out to get something else.
Yeah, I've been watching for about 5-10 minutes.
I did not. Yep, here he's back.
Guys, we're having problems with our printers here, the courthouse. All right, on the Dallas Berkshire Partners case, are both sides here now?
Yes, Your Honor.
So you guys have an agreed scheduling order. I just signed the confidentiality agreement, but you gave me two different dates for non-jury trial, March 28th or April 4th. So kind of tell me what's going on.
Well, those two dates were both available. We didn't know if you had a non-jury versus a jury week, and so we gave the court either date would be fine.
That's true. That's correct.
So I will say this, at this point, we don't have our non-jury or jury calendar for next year. So we don't usually get that until October and November. So I'm happy to set it either time. But I will say I am kind of concerned, this is a ways off, that we're just going to have so many jury trials that are backed up that it's going to be hard to get to non-jury cases next year. I'm not saying we won't get to any, but it's going to be pretty challenging. I assume that you couldn't get this ready to go in a few months. If this is going to take a year, you think, to get it ready?
I think so, Judge, given the fact that we're still operating under, circumstances of hopefully the beginning of the end as opposed to the end of the beginning of the pandemic. But this is not just a breach of contract suit. This also involves some tort claims for waste, which is going to involve some expert opinion. Also, given the current state of real estate leasing, it may need that period of time in order for us to more fully liquidate damages by having the premises relet, which has not occurred to date.
Okay.
That's another factor.
Are those March 28th or April 4th, or those both Tuesdays?
Yes.
Okay. My guess is those will probably both be jury weeks based on the last few jury calendars, but so it doesn't matter to me which date you set.
If the court's concerned about us going too far out, let's just go with the earlier date than I would.
Okay. Does that work for opposing counsel?
That's acceptable, Your Honor.
Okay. We'll go ahead and set that for March 28th at 9 a.m. And I just signed it, so you guys be safe, okay?
Thank you.
Thank
You
Your
too.
Honor.
Will we be excused?
You may. I think we have the, I assume no one is here on Jimenez versus Sorala. Okay, Zubarak versus Gonzalez. Is everyone here for that? I know there's always a big group for that case.
Robert Miller's here on behalf of Mr. Zubarik, who's joining us by telephone today.
Okay,
Greg Fell, Your Honor, for Francisco and Mary Ann Gonzalez. It's our motion.
And Kelly Milligan for defendant Ronnie Henderson, observing, chiming in as needed.
And Caitlin Coker for the defendants, the First Amended Phillips Family Trust, Mr. and Mrs. Sorensen and Mr. and Mrs. Smelser, also appearing as an interested party in the outcome of the hearing.
okay.
And good morning, Your
Sounds
Honor.
good.
David Atwood for the intervener, Charles Harrison McLean III, also observing today. It's not our motion, not responding. We can chime in as needed.
Tony, did you get all those announcements or do we need to start over?
I'm so sorry. Can you all start over? I didn't realize.
Let me just I was just mostly making sure everyone was here. All right, let's formally go on the record on cause number DC 1918220, Zubarik versus Gonzalez. Counsel, make your appearances.
Robert Miller on behalf of Mr. Zubarik, who is joining us by telephone today.
Greg Fell for Francisco and Mary Ann Gonzalez.
Kelly Milligan for Ronnie Henderson.
Caitlin Coker for the First Amended Phillips Family Trust, Eric Sorensen, Jamie Sorensen, David Smelser, and Lindsay Smelser.
David Atwood for intervener, Charles Harrison McLean III.
All right, let's go ahead and proceed.
Thank you, Your Honor. This is my motion. Just by brief way of reminder, Your Honor, this is a case involving an HOA and its member homeowners. The plaintiff sued several homeowners for erecting fences, permanent structures under the declarations in a utility easement, and the court granted summary judgment on the liability issue. Those same homeowners filed a counterclaim against Mr. Zubarik for his own substantial violations of the same restrictive covenant. He has erected, it appears, structures vastly more significant in his easement than the defendants did. On December 11th, I served Mr. Zubarik through his attorney with a request for entry onto his land for purposes of taking pictures and having a surveyor take measurements in furtherance of our claims against him. He objected on two bases. Number one, the date. Number two, that I had not provided the names of the people who would be present. Those were provided to him, and he was unwavering in his date. And that is at the time it was March 15th. He would allow us to come out there to do it. I think since then he's backed off that. Reading paragraph 3 from his response to this motion, quote, this is his statement, quote, "The trial is scheduled for August, so no reasonable need to do a new survey so early, nor to do it at all if the judge dismisses the case with a summary judgment." So what he's done in the interim, Your Honor, is he filed a summary judgment on our claims and is resisting us conducting any discovery. And attached to his motion are the affidavits of two people. One was signed on December 28th, and yet he failed to disclose them until February 7th. He's clearly trying to run out the clock, Your Honor. So I've done my best. I've got the email exchange in my motion showing how I attempted to work with him to compromise. He's been unwavering. Forgive me, Your Honor, I just lost my train of thought.
Let me hear from Mr. Miller.
Thank you.
Your Honor, Mr. Zubarik has admitted that there are permanent structures in the easement on his property. The survey or other inspection does not give any more information other than, yeah, we did that. But this was stuff that was built. A lot of it was built when the house was built in 1993, and there was no prohibition at that time about that. The statute of limitations is 4 years in this matter. And the last thing that was built in 2016, more than 4 years before they decided to file this lawsuit. And the other problem is that the surveyors would have to go up on the upfields, the next door neighbor's property, because of the line of sight. And we're not real sure what it's going to be, what extra they need other than, yeah, we have permanent structures there. And we're not denying that. We think we have a good statute of limitations defense. He gave them March 15th as a possible inspection date. But is there really any need for that if we've already admitted that, yes, we have those there? And Mr. Zubarik has some personal problems with a lot of people coming in taking pictures due to a very unfortunate event that happened in his life where someone was trying to kill him. Just briefly, I have Mr. Zubarik on the phone if you need to hear more about that, but he is really, really opposed to having anyone come in, taking pictures of his backyard and everything else.
So who are you proposing, Mr. Fell, would be there for this inspection?
We've identified a surveying firm, Burns, Timothy Burns, or somebody in his office. He's a professional surveyor. Myself, I imagine the other lawyers would want to be there as they're similarly situated. In no way is this designed to harass Mr. Zubarik. We have what we feel are good claims against him, and I don't believe they all have been admitted, Your Honor. There are structures we believe in the back that are obstructed from the street view that we need to look at. And just, I remember what I wanted to mention regarding the date. The reason we wanted it sooner was we have a scheduling order and amended pleadings are March 26th. And expert designation for us would be April 26th. That leaves us very little time to explore those claims.
Glad to extend that, Your Honor.
So I'm going to grant the motion. I am going to limit.
Could I just say?
I'm inclined to limit it to up to 3 people there for the defendant total. So the surveyor, I guess, if the surveyor has somebody else, and then maybe 1 attorney, and then the plaintiffs are obviously welcome to be there as well. I don't want to put, I don't think there's any reason in this case. I can't see how, and you guys are welcome to correct me if I'm not thinking of something, but I don't see how there's any, why each of the attorneys for each of the individual defendants would need to be present for this, unless there's, I think they're all kind of in lockstep on this particular issue, unless there's, something I'm not aware of. I could see possibly the need for someone from the homeowner association's counsel there, but Mr. Fell, Ms. Coker, and any of y'all have a feeling about that?
If I may, Your Honor, 3 seems like it might be just a little small. You are correct that the attorneys for the defendants are for the most part working, together on this. But that said, you're looking at 3 people there, the surveyor being 4, and if the HOA wants to have somebody present, that's 5. We're not looking to make this into a party, but we would like to make sure that everybody is in a position to see what's going on and represent their interests.
Okay, Mr. Miller.
Your Honor, I would like Mr. Zubarik to talk about why he is so opposed to this inspection, if that's okay with the court.
I don't feel comfortable doing that unless all parties agree and you guys want to turn this into an evidentiary hearing.
I don't know why it's relevant. The court's already ruled on the motion to compel. I mean, we regret that Mr. Zubarik is uncomfortable with this, but I can speak for my client. We're uncomfortable that we're spending a lot of money on this lawsuit. So sometimes these things happen.
Your Honor, my question is, if the surveyor has to go on the upfield property, that can't happen because we don't represent the upfields.
Not ordering that, so if you have to go on someone else's property, you're gonna have to get their permission.
And Your Honor,
Is
I'm
that
no
in-
surveyor. I don't know to what extent they need to be on the upfield property. Certainly, it will be no more intrusive than is necessary. I think much of it can be done from the Zuberic property.
Once again,
Does the order you've submitted, I'm going to allow you to go on to the the plaintiff's property. I'm not going to order you to be able to go on other people's properties without their permission. So that needs to be clear in the order. I think that 3 people is plenty. If can you guys agree who would be the representative for the individual defendants?
We'll agree, Your Honor. We'll work it out.
Okay. And then obviously someone from the homeowners. So what I would recommend is someone from the individual defendant, someone from the homeowners association, and then the surveyor. That would be my recommendation. But you guys can split up the 3 however you like, and then plaintiff can have as many people there as they like. Anything else, guys?
No, Your Honor. We'll circulate an order to get it to the court.
which day are we talking about, Judge?
March 15th, I thought.
Oh, yeah.
Okay. Just want to
Yeah.
make sure.
Your Honor, I'm sorry. We glossed right over that. That was a date that I thought was too late because of the scheduling order. We were pushing for a date much sooner than that. We made the request on December 11th. And I mean, we're now, gosh, we're talking about 3.5, almost 4 months later to get into the property.
Mr. Miller?
Your Honor, this lawsuit was filed back in February of 2019. They had plenty of time to make this new claim. And I'm more than happy to extend any deadlines they may have.
Your Honor, I don't think it was filed until November of 2019, actually, but that's of no moment. We did make this request as soon as we were able to ascertain that we needed it. We had a surveyor ready to go on January 11th, only to have Mr. Miller shut us down. We've tried to work with him. We've gotten nowhere.
We're going to keep it on March 15th, and if you need to get relief on other deadlines because of that date, then you guys can work it out or request relief from the court.
Not quite sure what the surveyor is going to add, but go ahead, Judge.
Okay. Anything else, guys?
None from me, Your Honor.
No, Your Honor.
All right, guys. You guys be safe, and we will, I'm sure, see you soon.
Thank you, Your Honor.
Likely.
Thank you, Your Honor.
Thank you, Your Honor.
Someone here named Chuck. What is Chuck here for?
That's Mr. Zuberic, Your Honor.
Okay. And he also has, I guess, a phone as well.
I don't know who the phone is, but the Chuck is Chuck Zuberic.
The phone is me, Your Honor.
Okay. All right, guys. You are released. Be safe.
Can we address the photo?
I've already ruled, man, sir.
Can we have in the order, Your Honor, that the photos are not distributed to
We don't
anyone
need to be
else?
talking about the order with
in
all
this
counsel
case?
not present.
Yeah, we've
Did
already,
somebody leave?
yeah, somebody already left. Why don't you address whatever concerns you have with opposing counsel, and if there's some additional, you need an additional hearing, you can have it. But I would think you guys can work this out. This is very standard on this type of case. So, and I've given you some accommodation by limiting to the number of people that will be there. So, all right, guys, thank you so
All right.
much. You guys
Thank
be
you, Your Honor.
safe.